Welcome to Civil Procedure, Subject Matter Jurisdiction, where we are going to focus in video 2 on diversity. The case that we are going to use to apply the diversity doctrine is Moss v. Perry. Now that we've looked at the constitutional baseline and the statutory narrowing of diversity, let's pause and put the pieces together. Diversity jurisdiction is not a single rule. It's a structure built from several doctrinal pillars. Think of it like I like to think of it as a triangle. One side of the triangle comes from Strawbridge v. Curtis. Another side of the triangle comes from Gordon v. Steele. And the third part of the triangle we will see comes from Mass v. Perry. So let's take a look at this doctrinal triangle. By now, we've traced two of the three essential arms of this diversity jurisdiction triangle. Again, the first arm is the diversity jurisdiction triangle arm of Strawbridge v. Curtis. Remember, in Strawbridge v. Curtis, that's where the Honorable Chief Justice John Marshall gave us the alignment rule. What's the alignment rule? Congress requires complete diversity. That means every plaintiff must be diverse from every defendant. The second arm of the diversity jurisdiction triangle comes from Gordon v. Steele. Remember, Gordon v. Steele is the case where we learned how to determine what state a litigant is a citizen of. The third arm, which is the one at the bottom here in this illustration, is Mass v. Perry, where we will see how arm one, complete diversity, diversity. Arm two, domicile, come together, are affirmed, and are morphed to include the amount in controversy. We've mapped out the three arms of the diversity jurisdiction triangle, but before we can really apply them, we need to anchor them. The Constitution gives us the outer limits, and Congress gives us the narrow gateway. So, baseline, remember the hierarchy. Article 3, Constitution, permits, but 28 U.S.C. 1332, that's the congressional enactment, the statute, actually governs. Minimal diversity with no amount in controversy required would be enough for Article 3's permissive view, but complete diversity and a minimum amount in controversy currently, actually since 1996, $75,000, which is exclusive, right? It exceeds $75,000, exclusive of your interest and cost, is what the Constitution requires. And that's the world that we live in. The best way to see these statutory limits in action is by walking through Mass v. Perry. So let's walk through Mass v. Perry. Some of the most important cases in federal jurisdiction don't begin with sweeping constitutional questions or even multinational corporations. They begin with ordinary, yet unsettling disputes at times. Mass v. Perry started with a landlord secretly spying on his tenants. I know that you've read the case. In 1974, the Fifth Circuit had a case that involved a newly married couple, that's Mr. and Mrs. Mass. Mrs. Mass was a citizen of Mississippi, and Mr. Mass was a French national pursuing his education actually here in Baton Rouge at Louisiana State University. The couple had dated for almost 2 years before they got married, and that's where Mrs. Mass was a domiciliary of Mississippi. Once the couple married, they moved together to Baton Rouge to work on graduate degrees. While in Baton Rouge, the couple rented an apartment from their landlord, Mr. Oliver Perry, who, as it was later, it was discovered, had secretly installed a two-way mirror in the couple's bedroom and bathroom that allowed Mr. Perry to spy on the couple. The couple sued Mr. Perry for invasion of privacy and damages. All right. At first glance, looks like it's a simple landlord-tenant dispute. But jurisdictionally, it raised a critical question. Could the couple bring their case in federal court under 28 U.S.C. 1332, diversity jurisdiction? Let's solve the mystery. The procedural posture of Mass v. Perry is as follows. Mr. and Mrs. Mass filed their original lawsuit in federal district court in the Eastern District of Louisiana, alleging damages based on their landlord's alleged invasion of privacy. Mr. and Ms. Mass invoked diversity jurisdiction under 28 U.S.C. 1332 as the basis for their federal subject matter jurisdiction suit. Mr. Perry, the defendant, challenged the jurisdiction, arguing that Mrs. Mass was actually a domiciliary of Louisiana. Therefore, there was no complete diversity. Therefore, the federal court would not be able to exercise jurisdiction. Well, let's look at the facts. Now, you will see in this very short video that I've divided the facts into three different categories because we're looking at three different cases that give us each arm that's required for this diversity jurisdiction triangle. So we're going to have facts that are going to come under complete diversity. We're going to have facts that come under domicile, and we're going to have facts that come under amount in controversy. For the facts that should be organized under complete diversity, that's the Strawbridge case, we have fact number one. Mr. Moss, that's John Moss, is a citizen of France. So as to the diversity statute, we're looking at 28 U.S.C. 1332 A2. Judy Moss was a domiciliary of Mississippi. That's going to fall under 1332 A1. Oliver Perry was a domiciliary of Louisiana, and that is undisputed. The facts that we are going to consider under domicile, which is our Gordon v. Steele case, are as follows. Judy Moss was a Mississippi domiciliary at marriage. Here's an example for all you trial advocacy fans. One fact may be able to satisfy more than one element. So I'm going to use the fact that Miss Moss was a Mississippi domiciliary in two different places. I'm going to use it under complete diversity, and I'm going to use it under domicile. Miss Moss's stay in Louisiana before and after marriage was only as a graduate student. Miss Moss testified, if you read the full opinion, which is very short, she had no intention of remaining in Louisiana permanently. But hold on, because she also testified that she did not intend to return to her parents' home in Mississippi either. Ooh. So she didn't plan to stay in the state where she was currently living, that's Louisiana. And she also didn't intend to go back to where she had been domiciled previously. We'll pin that fact. Hold on to that, because you might initially think, well, then she doesn't have a domicile because she hasn't expressed an intent to stay anywhere. Hold on to it. We'll come back. The last category where I'm going to include a fact for us to consider is the amount in controversy. And that fact is that the complaint that was filed by Mr. and Mrs. Moss was for damages in the amount of $100,000 each. $100,000 each. What is the formal issue statement? Assuming that this is an actual case that I'm working on with counsel while I'm in law school, right? What's the issue statement? Or assuming that this is a hypothetical for an exam. 3-point issue statement. What law is the governing law? 28 U.S.C. 1332. So I'm going to name it. Under 28 U.S.C. 1332, here's my legal question. Once everything is stripped down and once all of the bells and whistles are gone, here's the ultimate question that needs to be answered. Does a federal court have authority to exercise diversity jurisdiction when one plaintiff is a French citizen, the second plaintiff is a U.S. citizen, domiciled in a state that is different than the forum state, but currently residing in the forum state as a student, and the defendant is a domiciliary of the forum state, with the amount in controversy exceeding the statutory threshold. That's a lot. I really did it all, right? What rule of law are we going to apply to answer the question? 28 U.S.C. 1332. What is the question? Does a federal court have the authority to exercise diversity jurisdiction when? What are the facts or fact that is so vital that without that fact, we would have to have a different legal question? Well, in this one, we've got a couple. We have two plaintiffs. One's from France and one's from the United States. But the second plaintiff has a domicile outside of the forum state, but resides in the forum state. Okay, well, that's pretty important. So I really could reduce it to that fact. Got to get in the fact that my amount in controversy is going to be met. So again, these issue statements are ideas of how to set it up. You're all brilliant. I know you'll come up with something amazing. Let's go to Professor Washington's fact element map. Wouldn't have gotten through 28 years of practice without a fact element map. How do I put these things together? I know that the rule of law is going to give me certain criteria that I either have to meet or negate. And I know that I have so many facts that I don't know what to do with them all. How do I determine what facts are relevant? Well, the facts that are going to answer the question, the facts that are going to either help me establish what the rule of law says I have to establish, or helps me negate what the rule of law is telling me I've got to negate. Those are my important facts. Now, there's going to be some priority of those facts. Again, very similar to case analysis if you're preparing for trial. Yeah. But in an effort to try to help students build their process, we're able to put a map together akin to what I used to use as a trial attorney, as a proof sheet. How does this fact connected with this element yield anything that's going to either help me win my case or help me lose my case? So let's use the map. We're not going to go through all of these together because the beautiful thing about a video is you can stop it, you can start it, you can fast forward it, you can rewind it, so you can spend as much time or as little time as you want with this map, but we will take a couple just so that you can see how it works. Jean Moss was a citizen of France. What element is that going to go to? That's going to go to complete diversity, right? Complete diversity. One of the arms of my diversity jurisdiction triangle requires complete diversity. Well, got complete diversity for Jean because he's from France. That statutory hook is actually 1332A2. How is the court going to use that fact connected with that element, right? Anchored by that rule. How are they going to use that? The court will be able to hold that a French citizen suing a Louisiana citizen satisfies alienage jurisdiction. Check in the box. What about Miss Judy Moss? Well, originally, she was domiciled in Mississippi, right? So that's going to, I said it before, that's going to satisfy my complete diversity and my domicile, right? What's the outcome when I wet those two things together? Counts as a Mississippi citizen. Yay, yay. What rule is that anchored to? 1332 A1. How is the court going to be able to use that? The court emphasized that domicile, I told you to pin it. You can unpin it now. Domicile continues until a new one is clearly acquired. So the fact that Ms. Moss testified, no. Once we're done with our graduate studies here in Louisiana, we're not staying here. Well, hold on. We're not going back to Mississippi either, which is where my domicile is, but there's no intent to stay there indefinitely, and there's no intent to stay here indefinitely. Does that mean that Miss Moss doesn't have a domicile? No, because this is what we mean when we say that domicile is quote unquote sticky, right? The domicile that you establish is the domicile that you keep until you specifically announce or establish a different one, right? Where are you living? Where do you intend to stay? Well, until you find a place where you are living and you intend to stay there indefinitely, meaning you don't have a plan to leave, well, until you have a new domicile, your old domicile remains your domicile. Okay. Let's take a fact from the amount in controversy. The complaint filed by Mr. and Ms. Moss alleges damages in the amount of $100,000 for each. right? Where's that going to fall on that arm of the diversity triangle? That's my amount of controversy in my diagram, slide 2. That's the bottom line. The allegations exceed the statutory minimum of 1332A. Now, in this case, Moss v. Perry, 1974, the statutory requirement, the minimum required, was $10,000. In 1996, it went up to $75,000. That's why in this case it's not $75,000, it's $10,000. But it doesn't matter because they're seeking $100,000, right? This is what you need to take from this. Allegations made in good faith as to the amount in controversy satisfies the requirement. Boom. Allegations made in good faith as to the amount in controversy satisfies the requirement. Now, when we get to the analysis, we're going to get to have some conversation over the fact that that's not what the Mosses were actually awarded. They were actually awarded 2 different amounts. We'll get to it. And then Mr. Perry, the defendant, is going to argue, well, there wasn't diversity because they didn't meet the threshold. But hold on to it. We'll get there. Okay. Last one that we're going to play with or test is the fact that Miss Moss, that's Judy, testified she never intended to remain in Louisiana permanently. Of the 3 elements of the triangle, which element does that satisfy? Domicile. How does it satisfy it? Well, it negates an intent to stay permanently, right? So how is the court going to use that? Key testimony: presence in Louisiana was temporary, which means Louisiana was not her domicile. See, put it all together is really pretty easy. Let's look at complete diversity. The anchor rule for complete diversity is Strawbridge v. Curtis. That's where it comes from. Under 28 U.S.C. 1332, federal courts have jurisdiction over civil actions that are either between citizens of different states, that's 1332A1, or between citizens of a state and foreign citizens, that's A2. If you remember the previous video, we also have a 1332A3 and a 1332A4. In the previous video, I said for civil procedure purposes, usually we're only going to go 1332A1 or 1332A2 deep. Okay. From Strawbridge v. Curtis, 1806, we know that Congress requires complete diversity, which means no plaintiff can share citizenship with any defendant. We also know that citizenship is tested at the time that the complaint is filed. That means later changes in domicile do not affect the jurisdiction. Applying these principles in Moss v. Perry, the Fifth Circuit sorted that the parties as follows: Jean Moss, a citizen of France, which places him under 1332A2, satisfies the necessary requirement. Judy Moss was a citizen of Mississippi. As the domicile analysis showed, that Mississippi is her domicile, which places Judy Moss under 1332A1. Oliver Perry was a citizen of Louisiana. With those alignments, remember the alignment rule, with those alignments, the outcome is pretty clear. No plaintiff shared with Mr. Perry, the defendant, a state of citizenship. No plaintiff shared a state of citizenship with Mr. Perry. Got it? For Jean Mas, the case was alien versus state citizen, right? French citizen versus state citizen. Okay. They're not sharing a state of citizenship. Judy's case against Perry stood as a Mississippi citizen versus a Louisiana citizen. So they're not sharing the same state of citizenship. Why Mississippi? Because domiciliary is sticky. What does that mean? That you keep the domicile of the state that you have until you intentionally change it. Yeah? Okay. The Fifth Circuit emphasized this point. Jean's claim stood squarely under 1332A, and Judy's claim, once her Mississippi domicile was established, fit under 1332A1. The court reminded us that later moves by the couple, like their eventual relocation to Illinois, because they said, well, maybe Illinois, it doesn't undermine jurisdiction because it is determined at the time of the filing. Simple enough. Let's move on to our second arm, domicile. With domicile, we see that our anchor rule comes from Gordon v. Steele. For individuals, citizenship under 1332 is determined by domicile, not mere residence. Federal rule is clear. Domicile requires two elements. First, physical presence in a state. Second, an intent to remain there indefinitely. Both must be satisfied, or the old domicile continues. In Mass v. Perry, the court had to decide where is Judy Mas's citizenship. She started as a domiciliary of Mississippi. After marrying Jean, she moved to Louisiana, where she worked as a graduate assistant while her husband pursued his PhD. So the first prong is satisfied, right? The first prong is satisfied because she's now residing in Louisiana. Yeah. But what do we know? Residence alone is not a question. When Judy testified under oath that her stay in Louisiana was only temporary and it was tied to her husband's graduate studies, and that neither of them intended to remain in Louisiana once he graduated from his graduate studies, the mold was set. The court looked for objective evidence to confirm this intent, and it found exactly that, right? We talked about objective evidence. Mrs. Moss never registered to vote in Louisiana. Miss Moss never bought property in Louisiana. Miss Moss made no objective effort that could be found to integrate into Louisiana's civic life, right? Those omissions reinforced her testimony that her residence in Louisiana was only temporary. The court also addressed an important nuance. Judy testified that she had no intention of returning to her parents' home in Mississippi either. Ooh, but she's not in limbo. The law is clear. Until she affirmatively establishes a new domicile, Judy Moss keeps her old one. Indecision with a prior domicile does not negate the domicile, and it definitely does not create a new domicile. The Fifth Circuit also rejected this outdated rule that I know that you all probably scratched your heads with when you read it, right? The Fifth Circuit also rejected this outdated rule that a wife's domicile automatically followed her husband's. That fiction would have made Judy either a domicile of France, so she's not only given up her state's citizenship, she would have been given up her US citizenship, right? Or arguably, they could have tried to say that Jean, her husband, the French citizen, was a domicile of Louisiana, which thereby would have made his wife, under the old rule, a domicile of Louisiana. But right, that doesn't even work because under 28 USC 1332 A2, he's not. Jean is not a domicile of Louisiana. So it just didn't work anyway. So the outcome is very straightforward. Judy Moss remained a citizen of Mississippi. Done. So if we have a French national and a Mississippi domiciliary as plaintiffs, they're on the left side of the V, that's the verses. And you have the defendant on the right side of the V, who's a domiciliary of Louisiana. What do we have? We have no plaintiff sharing a same state with a defendant. Looks like complete diversity to me. Let's go to the next one. Amount in controversy. The third requirement for the diversity jurisdiction triangle, right? Something that we created, the triangle, nice. Under 28 USC 1332A is that the matter in controversy must exceed the statutory minimum. Again, at the time of this lawsuit in 1974, that threshold amount was $10,000. Today, it's $75,000, but the principle remains the same. The amount in controversy is measured by the plaintiff's good faith allegation at the time of the filing. This is important. Jurisdiction is defeated. This is important. Only if it appears to a legal certainty that the claim is really for less than the jurisdictional amount. In other words, federal jurisdiction does not depend on how much the jury actually awards. It depends on what the plaintiff good faith claims at the time that the lawsuit is filed. In Mass v. Perry, both Jean and Judy each sought damages in the amount of $100,000. Their claims arose from the shocking conduct, right? That whole secret mirror, I can see you, you can't see me fiasco, right? Those allegations were serious and easily supported by evidence and easy to believe that those damages would be more than $10,000, right? If you read the actual opinion, it appears as alleged that for the 4 months that they were living, that Mr. Perry actually utilized those two-way mirrors for 3 of those 4 months. Even though the jury only awarded $5,000 to Jean and $15,000 to Judy, the amount that was claimed at the time of filing, having been claimed in good faith, exceeded the threshold amount. So the court has reaffirmed that jurisdiction for diversity is determined at the time of filing, not by the outcome of the trial. Yeah? So good, so good. So having taken the facts, connected the facts to the rules of the three different arms of the diversity jurisdiction triangle, and after wedding the facts and those rules together, we get the final pieces that we add to come up with our conclusion. So what did the court hold? Let's get to the holding. The Fifth Circuit held that diversity jurisdiction was proper in Mass v. Perry under 28 U.S.C. 1332 because, one, Jean Masse, a French citizen, qualified for alienage jurisdiction under 1332A2, which means that Jean Masse did not share a state of citizenship that was the same as the defendant. Judy Masse, though residing in Louisiana, remained a domiciliary of Mississippi for 1332A1, since domicile is sticky, since domicile persists until a new one is established, right? And that Oliver Perry uncontestedly was a citizen of Louisiana. With those three different citizenships, no citizenship of the plaintiff was the same as the citizenship of the defendant. Now, what if Jean Masse and Judy Masse were both deemed to be citizens of, I don't know, let's say Mississippi. Let's say Jean wasn't a French citizen. And let's say that Jean Masse and Judy Masse were both citizens of Mississippi. Is that going to negatively impact my diversity? No. Because on the same side of the V, right, both of the plaintiffs share in common the same state of citizenship. That's fine. That's fine. It just can't be shared across the V. And as to the amount of controversy, the court held that the amount in controversy, the threshold amount, was satisfied because at the time that the case was filed, the plaintiffs, in good faith, claimed $100,000 in damages each. Let's go back to the rule. Here's your anchor rule. Ready? Under 28 U.S.C. 1332, federal district courts have subject matter jurisdiction where there is complete diversity of citizenship between the parties, and the amount in controversy exceeds the statutory threshold. Exceeds the statutory threshold, which currently $75,000, but it's moved several times. So exceeds the statutory threshold, and that's exclusive of the interest and the cost. Here's some important subrules. We talked about this in previous videos. I'm not going to add the completion of these subrules into my anchor rule, right? Unless I have a hypothetical that is asking me to address something specific in these subrules. So there's a subrule for complete diversity that comes from Strawbridge. We have a subrule for domicile that comes from Gordon v. Steele. Yeah. And then the amount in controversy subrule, which is the plaintiff's good faith allegation controls unless it, quote unquote, appears to a legal certainty, right, that the claim is less. That comes from St. Paul Mercury Endem. Did the holding? Let's look at the transition, because this one is a wrap. Mass v. Perry clarified citizenship of individuals, that's domicile, which is physical presence plus intent to remain. Complete diversity and amount in controversy is satisfied, right? What about corporations? Because we've been doing a lot with corporations up until now. What about the corporations? A corporation may exist in multiple places. We know that, right? Where one, right, when we're talking about the citizenship of corporations, one place that that corporation may be a citizen is in the state that they're incorporated. We know that. The other place that they may be deemed to be a citizen of is where they're doing their principal place of business. We know that. We know that. For basic general subject matter jurisdiction, we know that we're looking at the principal place of business. That's our Daimler case. If we're being more specific about our subject matter jurisdiction, and we are looking specifically under diversity, we now call that the nerve center test. Remember? Nerve center test. Okay, so what's coming up? What's on the horizon? What's on the horizon is Hertz Core v. Friend. Relatively recent. That's a 2010 case. And we're going to get some definitive answers on this entity that we refer to as a nerve center when we are looking specifically at diversity jurisdiction. Yeah? Hope it's been fun. I hope it is helpful, and I look forward to seeing you in the next video.